welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo, where we discuss all things estate planning and elder law, and well, hey, anything else we want to talk about. Now, on today's podcast, we are going to be talking squarely about estate planning and elder law, as I want to talk a little bit about planning in unsettled times. Before we get to that, we're going to just do our quick disclaimer, which is, remember, please do not take what you hear from this show, or any other show for that matter, to constitute legal advice. If you are looking for legal advice, please call an attorney licensed in the state that you reside in, who practices in the area of law that you are looking for advice in, and once you meet with them and they understand the facts and provide advice, that is when you could constitute that to be legal advice. Please don't take what you hear from this show or any other show for any other purpose other than informational, educational, and entertainment purposes. All right, excellent. Just a reminder, at Bellomo & Associates, we educate so what happened to my family does not happen to yours. We offer free educational workshops in the area of pre-planning. We'll discuss all things powers of attorney, last will and testament, revocable living trust, asset protection trusts, tax planning trusts, and all kinds of fun things that we will discuss in that workshop, as well as our crisis Medicaid workshop. If you or a loved one is going to need skilled level care in your home or in a nursing facility, and say the next 6 months to a year, you probably want to get the free educational advice in the crisis Medicaid area to understand what is available. We also have special needs planning, as well as life care planning and post-death administration workshops, where you can get free workshops and education in those areas. We will explain everything, we will talk pricing, and you will know everything up front. And if and when you are ready to hire us, we will be here and be ready to assist you in any way possible. Otherwise, you get some great education, get some great information, and when the time is right, we will be here. So that is a little bit about Bellomo & Associates. If you'd like to learn more about the workshops, please contact us at 717-845-5390. That's 717-845-5390, or check us out on the web at www.bellomoassociates.com. That's B as in boy, ELLOMO, associates spelled out with an S.com. Awesome. All right. So lately, I have been hearing a lot from clients, from prospective clients, people in the community, and what I keep hearing over and over again is things are so unsettled right now. The tax laws are up in the air. Different types of programs are up in the air. Whether certain things are going to be recognized in the future is up in the air. And everybody's kind of a little overwhelmed with what does all of that mean. And I've been thinking a lot about this, and my advice hasn't changed what I've been saying for probably the past 20 years, which is plan for today. You plan for today, you plan for what the rules are that are in place currently, and go from there. Now, what I mean by that is there are definitely rules still in place today. Now, what does that mean? That means currently, as we sit here, the federal estate tax limit allows an individual to pass with $13.99 million. If they're married, another $13.99 million. And as of December 31st of this year, 2025, on January 1st, it is set to come back to $5 million plus inflation, which appears to be somewhere around, let's say, $7 million a person. So for a husband and wife, that would be $14 million. Now, certainly that is less than $28 million. I acknowledge that. But it's still a significant amount that a husband and wife can have and still not have any federal estate tax. That is what we know today. We know today that that is all true. And what I recommend is do planning according to what is in place today. Now, if you're sitting here and you have more than, say, 7 million a person or more than 14 million a person, and you're saying to yourself, man, I better rush out and do some advanced tax planning, what I would say currently is just hold tight, right? Yes, we know that it's set to come back as of December 31st. But when you start to do tax planning, the only way really to do tax planning is to give up control. You can create a trust. It's an irrevocable trust. You have to get separate tax ID numbers. You have to pay higher trust tax rates. You have to give up ownership or control. You can't have say over what happens. You have to appoint a trustee. There's all kinds of things that happen when your wealth is greater than currently 14 million or 13.99, let's call it 14 million, and another 14 million. But if you have less than that, personally, I would not be doing anything at this time until we get to the end of the year to see what happens. Because if you're going to be giving up control, you want to make sure that nothing changes. You want to make sure that Congress doesn't increase that federal estate tax limit back to where it is as of January 1st of next year, because you can't really undo the irrevocable tax planning trusts. Now, one of the advantages of the style of trust that we use more frequently for people less than currently 13.99 million and another 13.99 million if you're married allows you to remain in control. It's in your social security number, same 1040, individual income tax rates, a lot of flexibility in those. When we're talking about federal estate tax planning, you lose the control. You lose all of that. You're paying higher trust tax rates. Your kids are not getting a step up in basis. So that's a huge step. And I personally believe that Congress will act this year and they will raise that right back up to where it is. But if we're sitting here at the last quarter of this year, let's say it's October, November of this year, and it's still scheduled to come back, and you have more than 14 million if you're a married couple, and you have more than 7 million if you're an individual, then I would definitely meet with your attorney who does tax planning, who understands tax planning, who understands how to get wealth out of an individual's estate, and then get advice. But I would not be doing it sooner, personally. The reason for that is years ago, the federal estate tax limit was, well, at one point it was 600,000, then it was a million, then it was 3 million, then I believe it was 5 million. And we've kind of run the gamut up to where it is today, which is 13.99. But back when it was a million in particular, I remember a lot of people doing federal estate tax planning, a lot of people doing irrevocable trusts, that you can't change it, that it is the separate tax ID number. And they did it because it was at a million, they had more than a million, and they didn't want their families to be taxed at a 55% tax rate. But then a year or two later, it went to 3 and then to 5. And now it's up to 13.99. So I have several people who worked with other law firms who rushed to get it done because they had a fear and they also had a legitimate potential tax problem. But they did it, and now they're sitting there with, maybe a couple million sitting in that trust, but they've given up control of that. It's outside of their estate. It's outside of their control. They can't have say over it. They can't control what happens to it. They can't get it back in their name. And they're going, well, wait a minute. I might have $3 million in there, but I was allowed now to have 13.99. Why did I do this? Why did I give up control? How do I get it back? And it is a nightmare. It is a mess. And there are a lot of people who are really hurt by that because, and no fault of anybody's. I want to be very clear about that. And in that moment, it seemed like the right thing to do. But I'm telling you, you got to think that through. You really want to understand what your options are. So for example, if you're sitting there, and you do have 13, 14 million, and at the end of the year, we're looking at each other and it's still set to come back to 5 million plus inflation. Yeah, we very well may take advantage of that. We very well may make a decision in the last quarter to get assets protected in an irrevocable tax trust, and we'll understand the consequences. We'll take advantage of the current $13.99 million exemption, certainly. But if you're sitting here listening to this and you don't have, 11, 12, 13, 14, 15 million a person, that isn't really going to apply at all to you. So that isn't something that you need to be worried about. That's not something you need to concern yourself with. And don't let that uncertainty concern you in any way. If you do have that kind of wealth, then definitely put a mark on your calendar, task yourself out to touch base with your tax planning attorney in the last quarter to make a determination if that exemption is something that you should take advantage of before it goes down. I will say that for our clientele, it's probably not going to affect anybody. If it does, it'll be one or two people. And even then, I think we still have some big decisions because of the fact that they have to give up control. And those of you who listen to our podcast on a regular basis, you know that control is what I believe estate planning is all about. So for me, I'm going to be hesitant, and I'm going to definitely make sure that the clients understand the risks. The client understands what that means. The client understands, well, what if the laws change and it goes straight back up and now you didn't have to do it? It's difficult to undo it. So let's just be very clear about the risks associated with it. And I also would say, even if you're in that case and you do have 13, 14 million, I wouldn't let the rest of this year make you nervous. I wouldn't let the rest of this year concern you or be unwary about it, because the truth is, at the end of the year, in the last quarter, they've either made a decision or they haven't. And depending on what they do, we'll know what to do in that instance. If they've not made a decision, that is a decision because it comes back to 5 million plus inflation, which means it's going to be right around 7 million. I suspect that's not going to happen though. So let's just play this out and see what happens. And we'll go from there on that one. Now, another one that is a kind of massive topic right now that I think has people very unsettled is we're hearing a lot about Medicaid cuts. We're hearing a lot about potential loss of funding and those types of things. On a daily basis, I'm reading different things about it. On a daily basis, I'm kind of hearing different things. By the time this podcast is published, there may be a final pronouncement on it. There may be already an official kind of word as to where things are going. My personal feeling is that it is virtually impossible to cut Medicaid funding when you have hundreds of thousands, maybe millions of people who are in nursing facilities receiving care. And the one thing that I stress in my workshops is that these places who are providing the care are doing one heck of a job. They are absolutely doing their best. I believe our system is broke. I believe it's the system's fault, not the places that you're receiving the care or your loved ones are receiving the care. And they have to be able to run the business. They have to be able to pay their team and have a little left over at the end, or otherwise they're not going to. So what are you going to do with hundreds of thousands of people who need care, who can't get it because they don't have the funds, because they were already qualified, and you can't put them out on the streets? You certainly are going to be very restricted on what the options are. My personal feeling is that that is not one thing that I believe is going to change. I don't see how you do that. I believe that there's other things that the government is looking to be able to go after, or to be able to cut, or to be able to do. I think this is one that they don't expect to touch, but they're saying it to kind of get people focused on that, so that that's what everybody's worried about. And then when this one is not touched, okay, that's a good thing. So that's just my personal feeling. Nothing about this podcast is a political statement whatsoever. Those of you who know me know that I don't talk politics. I don't have opinions on politics. Everything is myself. I don't discuss it. This is purely I just truly don't believe that can happen, because what's the resolution with hundreds of thousands of people who are receiving care in places that need to get paid or they can't run the business? So I would not be freaking out if you have a loved one in a nursing home. I really wouldn't. I think that they're going to be fine. And for those of us who are fortunate that currently we are not in that situation, we'll let the law play out. We'll let this play out to see where it ends up, I can say that when DRA 05 and over 96, which are the kind of pronouncements in the law on Medicaid, when they came out, the world was ending, right? When they came out, planning was over, Medicaid planning was over, you'll never be able to do anything again. And then a bunch of people who are far smarter than me got in a room and figured out exactly how to continue to do what they were doing for families, just a different dance, a different step, but yet everything still worked. And I can say in my 20 plus year career, that has always been the case. Even when laws change, there's almost always a way to continue to do it. While we might have to do a two-step or do something a little different on our dance moves, the ultimate result is going to be extremely similar to what it is. So I don't tend to worry about that stuff. I don't tend to stress about it. Even if something does change and how it's working, there's going to be a way that we can continue to do a very similar result that we are doing. And I personally don't believe that all the funding can be cut. That just doesn't make sense. There's no way that that can occur. So I don't stress about that, and I don't think that you should either. Another big one that we're hearing about right now, same-sex marriages. Is currently the law, and I know that there's been some rumblings about that changing. Again, same advice. If you are in a same-sex marriage and you are legally married, then I continue life, and everything is the way that it is, and nothing changes. If the laws change, then we will definitely meet with you. We will definitely plan accordingly. We will plan for a plan B, and we will put that in place and move forward. Again, there are going to be ways to get around some of the tax rules and some of the things that are occurring to some extent. If that occurs, certainly prior to that occurring, prior to allowing same-sex marriages, there was a plan in place. So if something were to happen, we would go back to the way that it was and kind of still do that type of planning. So if it occurs, talk to your planner and your attorney and kind of see what's available and what you can do. But as of the recording of this podcast, nothing has changed. We're hearing things, but again, nothing official. So I would not lose a lot of brain power over it to try to figure it out, because until it happens, we won't know exactly what it's going to look like. So once it does, we will figure that piece out as well. Also, just kind of big picture here as we're in 2025, there's some things that came out that I just want to remind people of as far as the Transparency Act, the Corporate Transparency Act, where individuals who have entities, LLCs, corporations, you're having to do a filing. That was on, that was off, it was on, it was off. I went ahead and just did mine because I didn't want to take a chance when I heard that it was back on at the end of 24. And then I heard that they weren't issuing penalties yet because they were kind of holding off on that if you're here in Pennsylvania. I just went ahead and did it. I know that that's a question that I keep getting a lot, which is, what do I do? It's on, it's off, it's on. I took advice of counsel and agreed that there was no harm in doing it. There's certainly nothing that I'm hiding. I own two entities, and so I just went ahead and disclosed them and said who I was and provided the information they need and paid the fee, and now I can just sleep at night knowing I don't have to worry about it. I just don't know where that's going to land either. If you're holding out, just pay attention, make sure that you're understanding the deadlines, make sure that you're understanding where the things are standing and what pronouncements are being issued so that you don't miss it. Because if they do end up enforcing it, those penalties are pretty stiff. And in my opinion, it just isn't worth it. So I would make sure that you pay attention to that for sure. Also, last year, the governor in Pennsylvania announced essentially that as of this year, Pennsylvania is going to be following the grantor trust rules of the federal government. The federal government has grantor trust rules that says that if a grantor of a trust is still, in control, it can still be in their social security number. They're not required to file separate trust tax returns. Pennsylvania always had a little bit of a different rule in that regard, and that is no longer the case, and that has been taken away. So if you have a grantor trust and if your accountant was filing separate trust tax returns, please reach out to your accountant to touch base on that to see if you should continue to do that. For those of you who have a grantor trust and on advice of your accountant were not filing, you can continue to do what you're doing. That is one that essentially is just mimicking now the federal rules and saying that you don't have to do the separate filings and everything can still be in the social security number. So that is sort of business as usual for a lot of our clients and for a lot of the people who we work with. But if for some reason you're new to the game, I just wanted to provide that as well, that is something that came out. And so we're kind of, at least in Pennsylvania, it's a good thing for us because now it's matching the rules and we won't have to do separate filings and stuff, which is really, really good. You can in Pennsylvania have grantor trust where the grantor is the trustee and where the grantor files everything on their individual returns. Those trusts are not exist. They don't exist for tax purposes. It's a tax neutral event. So not good, not bad, just doesn't exist, which allows us to not have to do separate filings, which is now what Pennsylvania follows, which are the federal rules. So that's a really good thing as well there for that. Secure Act. Where do we stand with the Secure Act? So the Secure Act was a rule that came out December 23rd of 2019, I believe it was. And then at like 2:30 in the morning. And, I always ask, why do we pass things in the middle of the night? Especially on Christmas Eve for those of us who celebrate. But nonetheless, it was a massive change in retirement accounts where prior to the Secure Act, a child, would have the rest of their life expectancy to stretch out the tax benefits or the tax consequences, I should say, not benefits. And now they have 10 years. So that's a pretty significant change for most children. Then they issued regulations. They had 2.0 come out. I have not recently heard of any other new pronouncements coming out. I will say, though, that that's another area where it wouldn't surprise me. And if it does, then again, we will just plan for it when it does. I think if you were going to ask me what is kind of the underlying theme of this workshop or this podcast today, I would probably say to you, plan for today. Plan for what the rules are, live your life for today, and don't worry about what could change or what could be different. There are a lot of very intelligent people in the world who will address the changes as they happen and then have a plan B, a plan C, and a plan D. And so we will certainly take advice of those really intelligent people, and we will have a plan B, a C, and a D. That is why we belong to several national organizations and are in touch with some of the highest intelligent people who plan in all of these areas that we discussed on this podcast today, so that we do have a B, a C, and a D. Do not stress yourself out. Do not worry about what might or might not happen in the future. The rules are today. And as I've always reiterated, I think that it's really important that everybody over the age of 18 has a financial power of attorney place. Name somebody who would make the financial decisions for you if you can't make it yourself. And I think a good medical power of attorney is a great idea. If you add a living will into that document, that makes it an advanced healthcare directive so that we know what you would like at end of life decisions. If two qualified physicians say that there's no realistic hope of recovery, you want to have a last will and testament in place. You want to look into trust planning, revocable trusts, potentially asset protection trusts. If you have more than 14 million, look into tax trusts, right? There's all kinds of different things depending on the wealth. But remember, estate planning doesn't have to do with money. Anybody who's over the age of 18, you're going to have maybe a bank account, you're going to have maybe a phone, maybe a car, maybe something in your name, in which case you would want to have at least the financial power of attorney in place. So planning itself doesn't depend on how much money you have. The type of planning that you may do very well may. and you're going to want to take care of your family. You're going to want to make sure that your decisions can be made, your medical decisions can be made, and that you make your end of life decisions and make sure that it passes on to the people you love the way in which you would like to do it, to protect them so that only they can access that money. And all of that you can learn more about through our free educational workshops at Belomo & Associates. You can check us out, 717-845-5390, or on the web, www.belomoassociates.com. That is B as in boy, ELLOMO, associates spelled out with an S.com. Definitely, we will be advising on all current rules, all current laws, and everything that we know currently. Now, what is the key word there? Currently. And again, live for today. Live for what the rules are, live for what the laws are today. Get yourself planned for and prepared for. You want to stay in touch with your estate planning attorney so that if things change, they notify you so that you can get the updates done so that it doesn't cause undue tax consequences to your family in the future. So that is all very important. And I can't thank you enough for being here today at the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we discussed planning in unsettled times and a way to look at it and to plan for today and discuss some of where things stand currently and what might change in the future. So thank you. I really appreciate you being here today. And until next time, I'll see you real soon.